Good evening. I am going to call to order the August 18th edition of the Cañon City Planning Commission. And Denise, would you call the order roll, please?
Good evening, I sure will. Chairman Troutman,
Here.
Commissioner Bellantoni,
Present.
Commissioner Grantham,
Aye.
Commissioner Martino,
Aye.
Commissioner Embry,
Here.
Commissioner Gill,
Here.
Commissioner Frida.
Here.
Okay, would you please rise for the Pledge of Allegiance? Thank you. So this evening we have elections for a chairman and vice chairman as those positions come up and they serve for 1 year. So I now open the floor for nomination for chairman.
Mr. Chairman,
Yes, sir.
I nominate Justin Grantham for chair.
Justin Grantham has been nominated for chair. Are there any further nominations? Okay, hearing none, then I believe we can do that by acclamation. Is that right?
Yes, it is.
Yeah. So we don't need a ballot, right? We don't need to vote either. Great. Now, we need nominations for vice chair.
I'll nominate Commissioner Embry.
Okay, Commissioner Embry's name has been entered for vice chair. These terms will expire June 30th of 2016, both the chairman and the vice chair. Are there any other nominations for vice chair? Okay, well then, hearing none, we shall, by acclamation as board members, these members then will serve as chairman and vice chair until June 30th, 2016, at which time there will be another election. Congratulations to both of you. Can I now have another seat, or do I stay here? Do I stay here? I'm leaving.
Mm-hmm.
Thank you so much, all of you, for all your support. Thank you.
You're still on the board. Now two.
Amazing how fast it works.
Commissioner Embry has to move to my other side now.
I'm usually on the right anyway. Oh, I'm sorry.
Okay, moving on, we need the approval of the minutes from the Planning Commission meeting held on July 21st, 2015. Are there any corrections or additions to the minutes?
I'd like to make a motion, we approve the minutes as they're stated.
A second.
Motion has been moved and seconded. Can I have a roll call, please?
Commissioner Troutman,
Aye.
Commissioner Bellantoni,
Aye.
Commissioner Embry. Sorry, Commissioner Martino,
Aye.
and Chairman Grantham.
Aye.
Commissioner Gill.
Aye.
We're now moving on to the opening of the public hearing. The provision of Cañon City Municipal Code and in the particular Title 17 thereof, the subdivision and development regulations, and the comprehensive plan of the City of Cañon City are incorporated into the record of this hearing as if set forth verbatim. Call on Ms. Terry Bernath, our city planner, for proof of notice.
Notice was mailed and the property was posted as required by law.
Would the applicant please come forward and identify yourself for the record and state your request?
Evening, everyone. My name is Ben Googans. I'm requesting a zone change for 721 Bar. It's currently zoned at R1. What's that?
Speak into
If
the
you
Oh,
could
sorry.
speak into the mic, yeah.
Sorry. Start again. Evening, everyone. My name is Ben Googans. I'm requesting a zone change for my property over at 721 Bar. It's currently zoned at R1. I'd like to get it changed to R1A.
Kind of a call from the report from the city planner?
Certainly. Mr. Googans is requesting a zone change from R1 to R1A. The R1A district was approved by council back in 2008, and it was intended to accommodate single-family homes and accessory structures on small lots that were created prior to zoning, and also in anticipation of future development that would be small lot development. I would point you to the standards that were not included in your packet but are in front of you on the dais. And I'll give you just a quick summary of the differences between R1 and R1A. There are some different uses. A lot of those really have to do with animals and types of agriculture. For instance, backyard chickens, although it's not on this list, can't ever seem to get away from those, are, as an accessory use, they are allowed in R1, but they are not allowed in R1A, which is the small lot development. There are some other livestock, for instance, that is allowed in R1, but not in R1A. But I would remind you that livestock is only allowed on parcels that are greater than 1 acre. Animal boarding, for instance, is allowed as a conditional use in R1, but not in R1A. So some uses are changed somewhat because of the small lot development. There are also some bulk and yard differences. The minimum lot area in R1 is 6,000 square feet, and excuse me, minimum in R1A is 3,500. There's a lesser lot width in R1A to 40 feet instead of 60. You get a little bit more maximum lot coverage in R1A, and you have some lesser setbacks. Mr. Guggen's lot is 5,160 square feet and 43 feet wide. So it meets that standard that is required in the zoning regulations. I would add, and I'll make just a brief note about this, the parcel meets the specifications in size and width. However, the small lots, this R1A was created to rezone small lots that were platted prior to the city's adoption of the zoning code, which was actually in 1941. This lot was created after that, quite a long while after that. It's basically an illegal lot. It was separated from the lot next to it at 721 Bar on several occasions and kind of reconstituted over time and then separated again. And since 2012, it's changed hands twice. And Mr. Guggen's just purchased it in the last couple of months. And we thought that, for one thing, the lot that's just to the east of him at 721 Bar is an abandoned property. The person who did own that is now deceased. They're, contrary to what Mr. Guggens indicated, there is no responsible party for that property right now, and there would be no one to participate in a subdivision should we have required that. And Mr. Guggens also wants to invest in the community. He would like to partake in the building incentive program and build a home. We would like for him to be able to do that, and rather than having him legalize it by plat, we would have him legitimize it by going through a rezoning and establishing his lot in that manner at this time. We support the zone change. We sent out 30 notices to surrounding property owners, had about 4 calls, and I think I had 1 additional call this week. People just wanted to know what that was. It's surprising how many people don't know what R1A is. I got to explain that to folks, and they were all fine with that. They actually are hoping that someone will come in on this block and do something nice. The Planning Commission, and I will point you to your findings of fact. If you would just go right past the staff report to the findings of fact and advisory report. We had been trying to get this into one motion, and I wrote it as 2. So I just wanted to alert you to that number 1 motion starts the Cañon City Planning Commission upon conducting a public hearing. And then after that, you will stop and do a motion, have a vote on those findings, and then you'll start your number 2 motion based upon the above findings of fact. Just to give you a little direction there. And I'll answer any questions that you might have.
Any questions from any of the commissioners?
I have a few. I have gone by the property, and the aerial photograph shows a shed which I knew was there years ago. It's no longer there. The other thing that does concern me, and I don't know if it would concern you or not, and ILC really doesn't prove a lot, and that's 28 years old, the one you showed us. In there, it specifically says it's kind of a guesstimate of what's on the property and what isn't. It's pretty clear that it's nothing there. However, how are you going to accomplish the setbacks and everything should you build a home in there that's real sensitive to side setbacks without a survey? I mean, the ILC that I saw, and as I was on the site, looks to me like they've taken for granted the neighbor's fence to the west is appropriate. I don't know if that's on the line or not. Are you comfortable with that? Or are we approving it just by legal description only, not worrying about that? I guess that's a question for you, Ms. Maria.
Yes, we are. It's really up to Mr. Guggens to do a survey of his property. When it comes to building, we do not require a survey. We leave that to the applicant to verify their property boundaries. And so we would be doing this based on the ILC that he provided to us.
But wouldn't the building department, I know that's a total issue differently, so we are approving it by legal description only, period.
That's correct.
And the other thing that I had seen before, although this is the distinction between a lot line adjustment, because there's no party on the other side of that old house to participate in this, there's no proof of ownership and there's no title company, there's nothing involved. We're taking someone's word for it that you own the property. I'm not doubting, but I don't see a deed, I don't see a title commitment. I see something from the assessor's office. I know the assessor never makes any mistakes. So we don't require that?
My understanding is that we do not. No.
Okay.
No, we don't require it on a rezone.
I think that's true. And maybe we should, but we have not historically done that. And we do investigate with respect to setbacks based on available information, which often is not a survey as such. Survey is better, agree with that, but it has not been required by the city.
And it's an interesting point, though. Who does own that house there? Is that a bank that would own it? I mean, what do you do with that? That's a mess.
I can actually answer that one.
Go ahead.
I went ahead and I did check with the treasurer's department, as well as doing a little bit of research on that corner lot, like you said, owned by Mr. Purdy. And actually, there are 2 lien holders right now attempting to buy that out from under him since he is deceased. Yeah, that's deep, right?
I think the property before that might happen would belong to the estate, whether one's formally opened or not. That would be the owner I'd look to first. And
Well, the other part of that is, what if that person does come in and say, wait a minute, we never agreed to that.
you're
Is
talking
that
about the shed again?
No, well,
or just
the house itself, we're taking and splitting off by legal description 18 feet and allowing the other half 7 feet. Is that could that create a legal problem with someone in the future who had a prior lien at one point in time that that was not their legal description?
Would be an issue in a civil proceeding. The lot was split long ago,
Was it?
several years ago. I concur with city planner. The split was, quote, illegal, but it happened and nobody caught it until recently, and we're trying to legitimize what is an illegal situation by considering this zoning request, which would fix the majority of the problem, if not all of it.
Okay, well, I think it would be, if we're approving it by legal description, I'm okay with that, because you understand there could be some problems there in the future. Okay.
I don't know if it's of any help. I mean, I do have a deed on it, and it's been approved by Stewart Title, and I'm not sure if that answers any of the part of that question or not.
Good starting point.
Yeah, I mean, I do have a legal deed for it, and it's
I
got
don't-
insurance on it, and
I don't doubt that. I just,
So-
we don't see it in our packet here.
Right.
And so, but if we're doing it by legal description, I guess we don't really care that much.
I mean, just if I could follow up on that
Sure.
just a little bit. If it were, I mean, I've done a fair bit of construction off and on amongst my other career, but in terms of this specific one, the legal description is fairly easy to follow. I think even by an amateur, in terms of where the street is at, where the neighboring property is at. If I were going to build right up to where the setbacks would be, or the side setbacks would be, then I think there might be room for really wanting to have a survey done. But my setbacks will be well within that, and I think there's plenty of room to play. So, and I do have this, and for my own benefit would be useful, is this survey, which was done in
1977. That's
77. Yeah,
it's not a
and
survey.
the house appears to be completely unchanged. The stone foundation is where it's at, and the surveyor at the time made marks on here and numbers on here that are pretty useful today to go off of. So from just pretty amateur sort of survey type work. So so for my own benefit, I feel comfortable with it. So
Sure, but I'd caution you, it's not a survey.
Sure.
It's an ILC.
right,
Okay.
right.
Okay.
Yes, Mr. Havens.
As long as the applicant has the floor, I had one question. Do you agree with the statements and presentation of the city planner with respect to this matter, for the record?
Not necessarily. I mean, one area that I have a little bit of question about, I guess I don't know enough, but something that seems a little strange is just the legality or illegality of it. It may not be an issue for the outcome of this, but to me, I think there's some unresolved questions there. If it's legal or illegal, and the term used of, I forget the term that was used, but basically, because there was an owner that had owned both parcels at one point, and then it was sold separately, and then it was come back together, and that coming back together makes it illegal. I don't quite understand how that
The
works. but-
subsequent conveyance after the parcels became together again in the hands of a
But-
single owner.
See, I guess I disagree with that. I mean, there was a whole
Well,
separate.
let me stop you. We can
Okay.
have this discussion out on the
Right.
front lawn
Sure.
as many times as you want, and I'm going to be a willing participant. But for purposes of this hearing tonight, where you're requesting a zone change, do you have any issue with anything presented by the planner and the staff recommendation that the zone change be granted on the grounds urged by you?
No, I mean, the essential recommendation by the city, no, I have no problems with that. I mean, that's.
Okay. I want you to be able to get where you're going and to have
Right.
made a record that
Right.
we're doing that.
Okay, it's just as long as the question of legal or illegal doesn't come into play, then I'm fine with the outcome.
We're in a much better position if the zone change is granted.
Right, exactly.
Any other questions from the board? Seeing none, we're going to close the public hearing. Are there any questions from the commissioners to the staff? Terry, I have something. When I was looking at this ILC, I saw the date, and then I saw that that frame garage was actually torn down, and a new garage had a permit opened in 2005. That was considerably offset, and we can see it in our packets on the overview map. I was wondering if that's going to be an issue. I know that garage is not there now,
That's correct.
but the concrete floor is.
It could very well be.
So is that,
In fact, I think there is a pad.
I didn't know if that was going to be a problem with encroachment.
I guess technically it is an encroachment.
But if the pad is on someone else's property, you don't have
Well, it goes on to,
license to build.
it goes on to our applicant's property. That's the only reason I'm asking. Are you aware of that?
Oh, yeah, I'm very aware of that, yeah. It makes, yeah, I mean, I could put it to good use, I don't mind.
Or should you sell it, that would be recited as an encroachment on your property.
What's the,
Should you sell the property and you get another ILC with that pad sticking over onto your property, most title companies will recite that as an encroachment. Whether they write over it or they accept it out, probably will.
I mean, in terms of practical, I mean, it's been chipped up and cracked, and I mean, I don't know who would really consider it a valuable asset, but.
Yep. Okay.
Commissioners have anything else? Then I'm closing the public hearing and call for a motion and a second on the finding of fact.
I'll give it a try since I'm no longer in your chair. My chair. Okay.
Rusty, huh?
So as I understand, this first one is the first one we vote on. Number 1. Okay. The land to be rezoned was zoned in error, and as presently zoned is inconsistent.
Can I
Yes,
ask you to back
yeah.
up and start at the beginning of the paragraph? The Cañon City Planning
Okay.
Commission?
Thank you. The Cañon City Planning Commission, upon conducting a public hearing on the above captioned zone change request, and after considering the testimony presented by the applicant, city staff, and any other interested party, finds as follows. Number 1, the land to be rezoned was zoned in error, and as presently zoned is inconsistent with the policies and goals of the city comprehensive plan, the master plan. Once this parcel was conveyed in its present configuration due to its size and width, it is no longer consistent with the specifications for the R1 zone district, and so is incorrectly zoned. The parcel meets the specifications for the R1A zone district. Do I then
Second
keep
that.
going?
Okay, you need to find at least one out of the 3 that meet the standards.
Should I
Meet
So the
that
motion is
standard.
made as a proper motion if you want to go on and discuss and vote.
I'd like to stop there.
I second that.
Call roll, please.
Certainly. Commissioner Troutman,
Aye.
Commissioner Embry.
Aye.
Commissioner Bellantoni.
Aye.
Chairman Grantham.
Aye.
Commissioner Martino.
Aye.
Commissioner Gill.
Aye.
Moving on, can I have a motion and a second for the recommendations of the commissioners?
On the findings of fact, the Canyon City Planning Commission hereby makes the following recommendation to the Council of the City of Canyon City: approval of the request for rezoning.
Have a
Second.
Any discussion? You call roll?
Certainly. Commissioner Embry.
Aye.
Commissioner Gill.
Aye.
Commissioner Troutman.
Aye.
Commissioner Bellantoni.
Aye.
Commissioner Martino. Chairman Grantham.
Aye. Okay. Meeting is adjourned.
Thank you.